Welcome to Canadian Justice. I'm Christine Van Gyn. Today we're talking about lockdowns and the impact they're having on freedom of religion. Throughout the country, we've experienced restrictions as a result of COVID-19, and places of worship have not been exempt. For example, in Quebec, places of worship have been closed altogether, and in other provinces, like Ontario, gatherings have been limited to no more than 10 people, regardless of the size of the building or social distancing practices in place. In British Columbia, one church has received tickets totaling over $18,000, and across the country, select places of worship have opened in spite of the looming fines. This begs the question, what are appropriate limits to one of our oldest and most fundamental rights, and how much deference should be given to the government decision to limit those rights? I work at a charity called the Canadian Constitution Foundation, which has been involved in a case asking the courts to answer this very question. And today, we'll seek to do the same with our guests. In our first segment, we'll be joined by Pastor Aaron Rock of Harvest Bible Church in Windsor and founder of the Reopen Ontario Churches movement. Later in the show, we'll be joined by our panel of legal experts to discuss whether the limits to our freedoms are justified. Pastor Rock, your church was fined for running a limited in-person worship, and you're in a community that's been hard hit by COVID. Could you tell me about how you came to the decision to remain open instead of, for example, running virtual services?
Yeah, well, thanks for having me on. So our decision was fundamentally fueled by our knowledge of what people need. We have lots of people in our church that are younger, they're vulnerable. Some struggle with suicidal thoughts, addictive behaviors. Some are in challenging marital situations or in challenging homes. So as we sort of weighed out the risk and reward of seeking to stay open versus closing down completely, our core leadership decided that it was in our best interest to try to remain open. And that resulted, of course, in me being charged under the Ontario Reopening Act.
So what do you think you can do to make sure, if you are going to run these services in person, to ensure that you don't have transmission of the virus in your church? You know, we know indoor spread is a problem. How do you keep people safe, and can you keep people safe if you continue to run indoor services?
Yeah, that's a great question. Well, obviously, life is full of risk and reward. So when you get your Ontario driver's license and you get on the road, you're putting people's lives at risk. But you weigh out the risk and the reward, because chances are you're going to drive for many, many years and not ever cause anybody bodily harm. In our church, we have a very large facility, about 38,000 square feet. We have 3 different worship centers set up. We can seat over 1,320 people. And so we were part of the Reopening Ontario Churches movement last spring. And we, myself and a colleague, wrote a letter to the Premier. It was ultimately signed by, I think, 445 other churches and synagogues. And we negotiated with the Premier to reopen. And that's where the percentage came from. We had the 30%. So in our church, if you were to compare us to, let's say, a Costco or a Walmart, people have told us time and time again, they feel way more comfortable in our church. Every other row of chairs is removed. Families are spaced out 6 feet apart. People kind of are channeled in certain pathways. They sit in their area. We practice physical distancing. So could someone catch COVID in our church? Well, of course they could. But frankly, they're much more likely to catch it in a big box store where people are packed into much higher numbers and literally rubbing shoulders with each other and touching the same products and exchanging cash or debit cards and these sorts of things. So we're pretty confident that in order to continue to meet the broader needs of people, that the church needs to remain open.
Yeah, so it's interesting you bring up the big box stores, which have obviously remained open. I think that there's a lot of argument that I hear is that these big box stores are essential. People need them to go buy their groceries or their paper towels or toilet paper. But I'm sure in your view, church is essential too. Just in 10 seconds, can you just comment on that?
Yeah, I would say the comment that you just made is reflective of sort of a reductionistic view of what human beings are. We are not just biotic beings. We are relational beings. We are spiritual beings. We're social beings. We're emotional beings. And the church is here to meet those needs.
Yeah,
I would also
absolutely.
just say
Dr. Rock, thank you so much. We don't have more time. We've got to take it to the commercial break, but thank you so much for sharing your story with us.
Very good. Thank you very much for having me.
Welcome back to Canadian Justice. Today we're discussing the COVID-19 lockdowns and their impact on Canadians' religious freedom. For the remainder of the show, I'm going to be joined by Professor Eric Adams from the University of Alberta and Mr. Ryan O'Connor, a lawyer who's representing a church that's been challenging the constitutionality of lockdown measures. Now, Mr. Adams, I'll start with you. Freedom of religion is clearly protected in the Charter, and this includes the freedom to worship in any way an individual chooses, including in person. This lockdown infringes on that, but you've stated it's not enough to just say a right is infringed. Under the Charter, governments can limit this right. Can you explain why, in your view, lockdowns of places of worship are justified?
Great. Thanks, Christine. I'll say at the outset that there's no question that a measure of this kind would never withstand constitutional attack in normal circumstance. So shutting down churches, telling people they can't have weddings, they can't have funerals, they can't go and be together in church or synagogue or temple, that is going to infringe your charter rights. The question is a government able to do so in the context of a pandemic in which nearly 19,000 Canadians have died, in which a healthcare system is on the verge in some provinces of incredible strain or near collapse, where surgeries are being canceled and the hospital is really not able to function. The question is, in that circumstance, does the Charter allow for a fairly blunt, bright line instrument of shutting down activities where people gather, including religious services? And because the Charter allows for reasonable limits on charter rights, in my view, there's not much doubt that during a pandemic and during the heart of that pandemic, when the healthcare system is in crisis, that a court would find that drawing those bright lines is a reasonable limit, unfortunate as it may be.
Okay, interesting. So, Mr. O'Connor, you were retained by the Canadian Constitution Foundation in a challenge brought by a Toronto church that was asking the court to allow it to reopen before Christmas. And you have argued extensively that these lockdowns aren't justified, that they're not a reasonable limit. Can you point to some of the ways that the lockdown of places of worship have gone too far?
Well, thanks, Christine. So it's clear that any sort of restriction on religious observance, so that could be, someone going to church or worshiping at the synagogue or at the mosque or the temple, is a violation of every Canadian's and Ontarians, in this case, right to freedom of religion under the Charter. But Section 1 of the Charter is the reasonable limits clause, as Professor Adams refers to, that the exercise of those rights are subject to reasonable limits. But the question is, what is a reasonable limit in these circumstances? If we look at the lockdown rules, the province is under an entire lockdown. Costco is open at 25% capacity. Certain stores are also open with capacity limits. But churches, mosques, gurdwaras, and synagogues are all capped in terms of their attendance at 10. That's not minimally impairing of the charter right to freedom of religion. Why can't a large church that has capacity, for example, of 1,000 have 11 congregants or 12? Why is there a hard cap? At Costco, there's a 25% cap on attendance, and the government and the health table in Ontario have decided that that's appropriate, that is a way to prevent viral spread because persons can space out. A large church or mosque can do the same thing, but they're subject to a much more stringent standard than Costco. I liken this to, the Church of God cannot have more than 11 congregants, but the Church of Costco is allowed to have 25% of its capacity filled with customers.
Now, Ryan, in that case that you were involved in, you were seeking, or the church was seeking an injunction. And can you let us know what has happened with that and what the next steps are?
Well, it's very tough to get an injunction in such charter cases, and it's moved beyond that stage now. The challenge is still ongoing, and we expect that there will be a court hearing on the main charter challenge sometime in the midwinter, I would say, perhaps as early as February or March.
Okay, great. So it sounds like the real issue at the heart of these cases is what is the right balance, and trying to determine, what is a reasonable limit, what is minimally impairing. And certainly in the context of a global pandemic, it's the government's expected to take action. When we return from our commercial messages, we're going to talk about what the government is actually doing and whether these limits on our rights, our most fundamental rights, are reasonable. We'll be back with our guests again right after this break. Welcome back to Canadian Justice. I'm your guest host, Christine Van Gyn. We want to jump back in with our guests about the discussion of lockdowns on places of worship. And Mr. Adams, I'll start with you. As you've said, under the Charter, governments can limit our rights, including the right to freedom of religion. But is a blanket prohibition that doesn't take into account the size of the actual building or the social distancing measures in place or case counts in different communities, is that casting too wide a net?
Yeah, thanks for that question. And again, I would say that in the typical course, a blanket prohibition is always more difficult to justify for a government that has infringed someone's rights. Why didn't they take a more tailored approach? Why didn't they, as you say, investigate the size of the institution or the capacity? And again, I would return to the question of whether or not a government can make blunt choices during a pandemic. And that to me is a separate question from what would be the optimal policy. Could you imagine a less restrictive policy? Why not allow 12 people to gather instead of 10? That's less restrictive. Or how about 15? Or how about let some churches open sometimes if they're big enough, but not others in other circumstances where case counts are higher? All those things you can imagine. And maybe a government should even have those policies. The question is during a pandemic, is a court going to say it's unconstitutional if you didn't take all those steps? And again, in my view, it's going to be very difficult to convince any judge that during a pandemic, the blunt instrument of a ban or a highly restrictive approach, given the unknown nature of how to actually manage this communicable disease, was a reasonable, maybe not the perfect, but the reasonable approach to limit the right.
Okay, so Mr. O'Connor, you represented the Canadian Constitution Foundation in a Toronto church challenge, and that church had extensive safety measures in place. But we know that indoor gatherings are a source of spread, and the government is expected to take action to keep the public safe. Does the existence of a global pandemic warrant the government getting more leeway or deference in limiting our rights in the name of safety?
I would expect that a court would be more deferential in the current context, but deference does not mean that the violation of the charter right is going to be upheld. Yes, there's a global pandemic. Yes, governments have the right to respond to it. But if a government is more likely, we can assume that a government is more likely to trample on constitutional rights when there is a crisis. So if the charter is not going to uphold freedom of religion or freedom of expression or legal rights in a crisis, then the charter may not be worth the paper that it's written on. And the court will look at the approach that government has taken with respect to other indoor facilities. It's allowing percentage capacity limits at Costco. Why can't that be applied to a church? And a court's going to look at the discriminatory effect as well on certain religions. Some conservative Jewish congregations are required to have a minimum attendance of 10 men in order to conduct a service, but there's a hard cap on 10 individuals attending religious services. So Jewish women in those congregations are actually prohibited completely from attending a service. A court is going to look at that and question how the government's approach is not minimally impairing of the charter right of those individuals or indeed other members of the community.
Yeah, so Mr. Adams, how do you respond to that? Big box stores in Ontario are open. You can go shopping for toilet paper or even teddy bears at Walmart or Costco, and those aren't engaging our charter rights. So how do you balance that? The government has made the decision to infringe on fundamental rights in some cases, but allowed indoor gatherings where those rights aren't even engaged.
Right. So the question is a bad policy in another area or some hypocrisy going to be allowed to undo a restriction against churches? And I would say, again, that seems to me a tough constitutional argument to win. The government is making its choices about where to draw appropriate lines, and clearly shopping for food is going to be in a unique category. That's just not an area that is replaceable in an online environment. And I take the argument that gatherings of faith cannot be replaced in the same manner in an online environment. But a government's always going to say that privileging the acquisition of food or other goods has got to be a top priority. And then again, I would just finish by saying that line drawing in these kinds of scenarios is always a difficult business.
Okay,
but the Constitution
Professor Adams,
doesn't say where to draw those lines.
thank you so much for answering that. We'll be right back after this commercial break. Welcome back to Canadian Justice. Today we're discussing the constitutionality of lockdowns on places of worship. Now, Mr. Adams, I want to follow up with you. A pandemic doesn't dilute the requirements for governments to justify limits on our rights. Do you think the government has presented enough evidence to justify the limits they've imposed, especially when they aren't being debated in the legislature? It's just relying on broad public health and public safety goals. And is that enough to justify these limits to our freedoms? What evidence does the government need to present in order to limit these rights?
Thanks. I think a court would say that the evidence required is taken from the context of the particular situation. So I think the government is able to say, in the context of an emergent pandemic in which science is still being developed about the nature of the disease, the variables that are in play, the ways in which the disease spreads, and what actions by governments may curb that spread, that there's a lot of unknowns in that scenario. And so the government is going to be held to be making rational, reasonable arguments and putting forward what evidence they have. But there's going to be no expectation that they have clear, scientific, rock-solid evidence that this number of people are only allowed in this kind of institution, because frankly, that evidence just doesn't yet exist.
Okay, so Mr. O'Connor, I want to say today all of us here have the same goal, and that's to strike the right balance between safety and freedom. So what do you think the right balance would be that achieves the goal of stopping COVID, but also preserves our fundamental rights?
Well, certainly with respect to the religious services restriction, I don't see why government can't take the same approach that it takes to indoor facilities where there's a consumer element. So, Costco, as I stated earlier, has a 25% capacity limit in Ontario. No one is arguing that a church or a synagogue or a mosque should be packed to the rafters with congregants in the middle of a global pandemic. No reasonable person is arguing that. No reasonable person is arguing there shouldn't be sanitization standards, hygiene, and mandatory masking if appropriate, depending on the type of the facility. But the question is that the rules should be applied universally, particularly in circumstances where we're engaging a charter right, such as freedom of religion. So why not just apply percentage capacity limits across the board to all indoor facilities instead of discriminating against individuals who wish to assert their charter right of free religion by worshiping at the institution they choose to?
Okay, and so Professor Adams, just in 30 seconds or less, the government is not debating these orders in the legislature. And you've talked about how the courts are likely to give a lot of deference, but should the courts actually maybe apply more scrutiny since we aren't getting legislative scrutiny in this case?
Sorry, I'm sorry, I lost that question.
So should the courts apply higher level of scrutiny because these orders aren't being debated in the legislature? They're imposed by sort of under emergency legislation.
I don't know that that will be a variable when it comes to weighing the infringement and the reasonable limit. They are the law. It is law, and so the question really then is just, has it infringed your rights? And if it has, is it a reasonable limit given the context?
Okay, interesting. So, I have concerns that these aren't being debated, but I guess it's not a question that the courts might even consider. I want to thank you both so much for joining us today. It's been a really wonderful discussion to try and strike what the right balance is here. We all want to achieve both freedom and safety. So thank you both so much for joining us.
Thanks, Christine.
Thank you for having us.
Today, we've heard about how lockdowns on places of worship violate the fundamental right to freedom of religion, and that while governments can put limits on our rights, those limits can't cast too wide a net or do more harm than good. We've also heard that in-person fellowship is important for members of all faiths, whether you attend a church, mosque, synagogue, or temple, and that government is not the decision maker of how people can practice their religion. For many people, meeting in person is important for their mental and spiritual well-being. No doubt there's disagreement about what the right balance is between health and freedom of religion. The government's expected to take action against a deadly virus, but they're also expected to protect our civil liberties. But what do you think? Has the government struck the right balance in its effort to reduce the spread of COVID-19? Or have they gone too far in limiting important freedoms? You be the judge. Let us know your thoughts on our social media platforms and exercise your ability to speak out on issues that are important to Canadians. I'm Christine Van Gyn. Thanks for watching Canadian Justice. And remember, a freer Canada starts with you.